Check 1 2. 1 2. Audio 1 2. 1 2. Audio 1 2. 1 2. 1 2. All right. Yeah. Okay. Yeah. 1 2. 1 2. Audio 1.
I've always been. He is like a face of rivalry. He's just still good friend. I don't know why I'm doing it. I don't know. But I mean, somebody has to do it.
You're welcome.
Hello, how are you? Recognize you?
Things. I'm late today. I'm late. Hi. Looking as glamorous as always. Yeah, hi. Man of the hour. How are you? Happy New Year. Just needed one from you.
Miss Margaret, not Margaret,
Morning, morning, morning. I'm good, I'm good.
Red will advance. Left third. Hold up, change direction. Action light. And go. Hold up right there. Quick, come on.
Happy New Year, sir. Welcome, welcome.
Wait. Order. Arms. In open order. Inward dress. Steady! Stand! Hey! Now for run! Just like the third man. Steady! Footman, just like. Steady! Just forward a bit to footman. Steady! Stand! Hey! Now for run! Right! On front! Wait! Standard ease. Wait! Wait, send! Wait! Standard ease. Stand easy. Wait! Wait, send! Shoulder, arms! Wait! General salute, present, arms! Wait! Shoulder, arms! Order, arms!
General salute, present arms. Red, shoulder arms. Order arms. Stand at ease. Red, red, send. Red, shoulder arms.
Oyez, oyez, oyez. All manner of persons having anything to say or do at this His Majesty's Grand Court holding here this day before Her Ladyship, Honorable Madam Justice Ramsey Hale, Chief Justice of the Cayman Islands, Honorable Judge of the Grand Court Justice Williams, Honorable Judge of the Grand Court Justice Richards KC, Honorable Judge of the Grand Court Justice Carter, Honorable Judge of the Grand Court Justice Doyle, Honorable Judge of the Grand Court Justice Asif KC, Honorable Judge of the Grand Court Justice Peters, Honorable of the Grand Court, Honorable Justice Siegel, draw nigh and give their attendance, and they shall be heard. Oyez, oyez, oyez. God save the King.
Please remain standing.
Right, I think I can do without that. Yes. My voice is always loud. All right, I'm so happy to be here today just to read a scripture from the Word of God and to pray a prayer of blessing over you. I must say, first of all, that I am a father of 4. Every once in a while, I have to be a lawyer. 4 girls. Every once in a while, I have to be a lawyer, a judge, and a magistrate. But I thank God that He brings help. The scripture says in the book of Psalm 121, I will lift up mine eyes unto the hills, from whence cometh my help? My help comes from the Lord, the maker of heaven and earth. He will not allow your foot to stumble, and He will not allow you to be moved. Behold, He that keepeth Israel shall neither slumber nor sleep. The Lord is thy keeper. The Lord is thy shade upon thy right hand. The sun shall not smite thee by day, nor the moon by night. The Lord shall preserve thee from all evil. He shall preserve thy soul. The Lord shall bless thee, thy going out and thy coming in, from this time forth, and even forevermore. Today I want to pray a prayer of help for you. I appreciate all that you do, but every once in a while we need help. Every once in a while we have to look up from whence cometh our help. And I thank God today that there is help available. I'm going to pray that over you today. Shall we pray? Father, we thank you. We thank you, Lord, that you are here. And we thank you that your presence, Lord, is invited in this place. And Lord, we look unto the hills, from whence cometh our help. Our help cometh from you, the maker of heaven and earth, the maker, Father God, the creator and the sustainer of the universe, the one who founded these islands upon the seas. And so, Father, we humble ourselves before you, asking you right now that you will come and give wisdom and understanding and grace and peace and strength. Father, we pray that this year would be a great year. And we pray, Lord, that you just open up the windows of heaven and pour out a special blessing upon every person in this room, Father, upon every dignitary in a special way. And we pray that you'll preserve them, that you'll go with them, Father, everywhere they go, that you would lead them. Father, would you allow your Holy Spirit and your holy angels to cover them? Would you allow your blessings to fall on them and their families in a very special way? As we open this session with your presence, Lord, we thank you that when we seek you first, all these things shall be added unto us. We give you glory, honor, and praise in Jesus' precious name. And everybody say, Amen.
Thank you. My thanks to the pastor for that excellent prayer that will start us off and for reminding us of that verse. I have to say, this is a wonderful crowd. It feels as if we're hosting a concert of some kind. The attendance is so large and the audience is so rapt. I'm very pleased to be joined today by my brothers and sisters in the judiciary. I won't call their names out again, since that has been done so ably by the lead marshal, Keon. But joining me and my brothers on the Grand Court are our colleagues in the magistracy, the Chief Magistrate, Her Honor Mrs. Angeline Hernandez, their honors, Mrs. Kirstian Gunn, Miss Vanessa Allard. Right. And they join me in extending a warm welcome to Her Excellency the Governor, to the Premier, the Honorable Andre Banks, to the I was going to say Deputy Premier, but I'm not going to say it. Might as well put this down and just call who name I know. The Speaker of the House, the Honorable Isaac Miller, the Deputy Governor, the Honorable Franz Manderson. I just stop here in the middle of my welcome to say that this is going to be his last opening as Deputy Governor, but I hope it will not be the last time he accepts an invitation to come to these proceedings. He's joined by the Honorable Deputy Leader of the Opposition. We just said hello on the steps. That's what you call, what's that? Of course it's Kenneth. I've only known Kenneth for 25 years. Honorable Mr. Kenneth Bryan, I think I'm showing my age. I think I should stop calling names in case I forget any more. So the honorable elected members of Parliament and other members of Cabinet, special welcome as ever. I'm sorry to single her out, but I have to. Chief Officer Gloria McField Nixon, upon whom my office relies heavily for assistance in administrative matters. This occasion has particular significance because it brings together, I think one time, the only time for the year, representatives of all three branches of government, the executive, the legislature, and the judiciary, and I emphasize the three branches of government, as it is a matter of constitutional principle, not form. The judiciary is not a department of government, as some still think. Just yesterday, I received correspondence to the Chief Justice at the Judicial Department. The judiciary is, in fact, the third branch, independent, co-equal, and entrusted with the responsibility of interpreting and applying the law, administering justice, and upholding the rule of law and the Constitution. And in fulfilling that role, the courts exercise lawful scrutiny over the actions of the executive and other public bodies through the process of judicial review. Experience has shown that this constitutional role is not always as well understood as it might be. We were recently referred to as a judicial ministry by a member of the civil service. That's even worse than being a department of government, I think. And so I take the opportunity of the opening and the presence of members of the executive and the legislature to make that point. To continue with my welcomes, I am hoping that we are joined by Mr. Justice Kawili, who, as you know, left us last year, but I believe has joined us by Zoom. I think I have a very warm welcome to a special guest, the Honorable Judge Robert Mark. Is Robert here? Thank you. He's a U.S. bankruptcy judge from the Southern District of Florida, who is here for a conference hosted by the American Bankruptcy Institute. The website advertises a conference as a midwinter escape. For Judge Mark, I'm sure it doesn't matter because he comes from Florida, but I'm sure many of his colleagues who join him are grateful for the midwinter escape. We wish the judge and his U.S. colleagues a very successful conference, and hope that they will have the opportunity to experience what we call Caymankind, which is Cayman's unique hospitality and culture, something I hope that this court is evidencing as your first encounter with it. Welcome too to all members of the profession. Thank you all who have come robed and bewigged. If you watch matters in England, you might think that the wig is in danger of extinction. I don't know if this will be the last time we see counsel bewigged and berobed in these courts. I know there's been a movement for years among some to abandon what must be the most obvious mark of our profession. I welcome two officers of the court, other officers of the court, representatives of the media, and everyone who has joined the proceedings by live stream or is watching on YouTube. Although we are well into January, I take the opportunity to wish all of you a year where your boldest initiatives succeed, and express a hope that our beloved Cayman Islands will continue to flourish as a result of our collective efforts. I now call upon the Attorney General to move the motion for the opening of the court.
Thank you, my lady. I was hoping to be able to say that I would adopt the protocol, but I think I'm obliged to go through the list again.
Yes. I rely on you for that.
Okay. My lady Chief Justice, the Honorable President of the Court of Appeal, I'm assuming they're following my lady, and other Justices of Appeal, Honorable Judges of the Grand Court, Honorable Chief Magistrate and other magistrates, Madam Solicitor General, Mr. Director of Public Prosecutions, President of the Cayman Islands Legal Practitioners Association, our Commissioner of Police, President of the Justices of the Peace Association, Chairman of the Judicial and Legal Services Commission, special guest, colleagues from the public and private bars, ladies and gentlemen, both present and joining us online, as well as Judge Mark, welcome. A pleasant day to you all, and warm greetings for 2026. At your invitation, my lady, Chief Justice, I rise to move the motion for the opening of the Grand Court for the year 2026, and in doing so, as is usual, I seek your indulgence to reflect on the past year and to share a few observations on the path that lies ahead. Before doing so, my lady, allow me to again express sincere gratitude to the various members of government and public administration who have joined us today. I extend special thanks to Her Excellency the Governor, now attending her third opening of the Grand Court. Thank her for her continued advocacy for the rule of law and good governance. I also recognize the Honorable Premier, Honorable Deputy Premier, acting, whoever, Honorable Speaker, or Honorable Deputy Governor, other honorable members of Cabinet, Honorable Deputy Leader of the Opposition, and indeed all honorable members of Parliament. My lady, their consistent participation at this ceremonial opening stands as a visible reaffirmation of their ongoing commitment to the fair and effective administration of justice, and by extension, the rule of law. My lady, as is also customary on this occasion, we pay tribute to members of our legal fraternity who sadly passed away in the preceding year. And in 2025, we record with great sadness the passing of Mr. K.C. Gill, a distinguished Caymanian legal practitioner whose career spanned almost 6 decades. Mr. Gill was among the early pioneers of Cayman Bar, practicing first alongside the Honorable Truman Bodden before founding his own firm, C.S. Gill & Co. His deep commitment to justice, education, and community service through Rotary, the Chamber of Commerce, and the National Trust leaves a lasting legacy, my lady. We extend our sincere condolences to his family and loved ones. We also extend our regrets at the passing of Sir Peter Cresswell, former judge of the Grand Court, the Financial Services Division, for approximately 5 years. Prior to that, Justice Cresswell served in the Queen's Bench Division and the Commercial Court of England and Wales. He was a strong advocate for mediation. Allow me to also extend, my lady, condolences in the passing of Ms. Colleen Williams, HR Manager for the Portfolio of Legal Affairs and the Office of the DPP. My lady, 2025 was a year of continued progress and further reinforcement of our justice and regulatory mechanisms. The work to strengthen our national frameworks against financial crime continued apace. Following the conclusion of the Financial Action Task Force enhanced monitoring of the jurisdiction, Cayman has continued to build upon its reputation for cooperation and compliance. One important institutional development has been the establishment of the Office for Strategic Action and Illicit Finance within the Ministry of Financial Services and Commerce. This new office, into which the Anti-Money Laundering Unit has transitioned, will provide enhanced strategic leadership and coordination as the jurisdiction prepares for the next FATF evaluation in 2027. I wish to congratulate the Honorable Premier and Minister of Financial Services for his vision with this initiative. Complementing these efforts, my lady, the Financial Reporting Authority continues to play a central role in safeguarding the integrity of the financial system. The FRA's work in receiving, analyzing, and disseminating financial intelligence remains critical to the jurisdiction's defense against illicit finance. We extend our appreciation to the Director and his team for their commitment and professionalism in supporting Cayman's national security and financial integrity objectives. In parallel, my lady, perhaps the highlight of any report card at this opening has to be that the jurisdiction has been fully transitioned from the Legal Practitioners Act to the Legal Services Act as it relates to the regulation of our legal profession as at the 1st of January 2026. And personally for me, my lady, it has only been 25 years of effort. The Legal Practitioners Act, which was enacted in 1969, when the practice of law in Cayman was largely criminal and general civil litigation, a bit of probate and estates, and some property conveyancing, and at a time when there were about 26 attorneys on the roll, one stipendiary magistrate and one judge, with the stipendiary magistrates often doubling as the judge.
Yes.
That piece of legislation has served us well, but is clearly no longer fit for purpose in an era where we now have over 1,200 attorneys on the roll, approximately 10 Grand Court judges and 6 magistrates sitting weekly at any given time. We now have a financial services, a family, criminal, and commercial division of the Grand Court, and Cayman law being practiced globally, among other changes, lady. I want to say thanks to you, my lady, for your leadership. Also, the hard work of the Cayman Islands Legal Practitioners Association and other attorneys, as well as the original Legal Services Council members, Mr. Stephen Watler, Mr. Aaron Merrin, who I gather is celebrating 50 years at the bar this year, my lady, Mr. John Magoo, Ms. Gina Ebanks, and special thanks also to Ms. Karen Stephen Dalton, a resource person at the Ministry of Financial Services. And thanks also to Mr. Eric Bodden and Mr. David Collins, as well as other stakeholders, my lady, for their entire effort in getting us cross the line. My lady, the full implementation represents years of effort and advocacy by many stakeholders, different governments, chief justices, members of the law associations, and others. And we are grateful to all. We will now turn our effort, my lady, to promulgating a new mandatory code of conduct for the profession. My lady, concomitant with this development are the changes to the regulation of the legal profession's anti-money laundering obligations. The Legal Services Supervisory Authority, the LISA, has now formally assumed responsibility for AML supervision of firms and sole practitioners engaged in relevant financial business. This transition from the CARA marks a further strengthening of the Cayman Islands AML regime, bringing it, my lady, into closer alignment with the global standards. All attorneys are now required to register with LISA, which will adopt a risk-based approach on supervision and compliance of attorneys for AML purposes. I'm also pleased to highlight the appointment of Ms. Shanae Donovan as the newly recruited head of LISA, and whose leadership will help to ensure that the authority fulfills its important regulatory and supervisory mandate. I wish to acknowledge the hard work and cooperation of all those involved, including SILPA, whose president, Mr. Richard Barton, has recently been elected, not surprisingly, my lady. I congratulate him and his new executive, including his vice president, Ms. Sophia Scott. I wish to commend the association for its continued investment in education and training of the next generation of Caymanian attorneys. Their efforts speak to a profession that is committed to modernization while remaining grounded in integrity, transparency, and excellence. Turning to appointments, my lady, we also extend heartfelt congratulations to Sir Anthony Smelly, KCMG, KC, our own former Chief Justice and now Justice of Appeal for Cayman Islands and Bermuda, and his appointment by His Majesty the King to the Privy Council in February of 2025. This latest honor is richly deserved and recognizes his decades of exemplary judicial service and significant contributions to Caribbean jurisprudence. This important appointment puts Sir Anthony at the zenith of his judicial career and is one that we celebrate with immense pride and joy. I'm pleased to also note several other distinguished new members of the judiciary and public service. And in February 2025, Justice Emma Peters was sworn in as a judge of the Grand Court and now serves in the criminal division. Justice Peters brings extensive judicial experience from the United Kingdom, including service as a circuit judge and legal chairman of the Pensions Appeal Tribunal for Scotland. We warmly welcome her to the Cayman bench and wish her every success in this new chapter of her distinguished career. We note, my lady, her willingness to temper justice with not only mercy, but a bit of high voltage where necessary. Congratulations are also extended to Justice Williams and his significant election as chair, president of the Commonwealth Magistrate and Judges Association, an achievement, my lady, that brings immense pride and joy to our jurisdiction. My lady, the Insolvency Rules Committee, chaired by our Justice Siegel, as usual, has been very busy in 2025. They've been involved in work which include work on amended rules supporting restructuring officer regime, as well as a scheme for arrangements, among other things. The Grand Court Rules Committee, chaired by your lady, has been equally productive in 2025. Its work included proposed revision to Order 53 on matters such as the court's ability to conduct leave application on an inter partes basis on the papers, and the introduction of practice directions and remote hearings, the delivery of reserved judgments, and the use of AI in legal proceedings. And on this latter initiative, my lady, we want to thank Justice Asif for taking the lead. Turning to education, my lady, I wish to again commend the Truman Bodden Law School director and staff for another successful academic year. The school continues to produce high-caliber graduates, several of whom were admitted to practice during 2025. We note, however, my lady, that Director Mitchell Davies, who has been with the law school for over 3 decades, will be retiring later this year. His tenure and stewardship of the TBLS has been stellar. He has been a visionary leader whose impact will endure long after his departure. My lady, as always, the work of our legislative drafting department has been tireless, producing and refining essential legislation across a broad spectrum of subjects. I extend heartfelt appreciation to Michelle Neblett and her drafting team for their continued diligence, dedication, and professionalism. Some of the significant legislation dealt with last year included the Cayman and Protection Act, Enhanced Beneficial Ownership Act and Regulations, a new minimum wage order, and the Land Holding Companies Share Transfer Tax Amendment Act, among others. This year we will see legislative reforms, which may include modernizing notary's public framework, introduction of demerit point system for traffic violations, among others. The Law Reform Commission remains deeply engaged, my lady, with major projects. Over 2025, their work included final reports on adverse possession, as well as foreclosure with proposed amendments to the Registered Land Act, and the establishment of an Administrative Appeals Tribunal. The tribunal bill, which seeks to establish a centralized tribunal to determine appeals against decision of a range of administrative bodies, will be debated in Parliament in February. My lady, I should add that 2025 marked the Commission's 20th anniversary, a significant milestone marked by a vast body of extensive research, and reports into legal subjects including arbitration, charities, enforcement of foreign judgments and interim orders, anti-bullying, director's duty, among others. The Commission has played a pioneering role, my lady, in advancement of laws in Ireland, ensuring that they are responsive to the ever-changing needs of the community. Our thanks to the Chairman, Mr. Hector Robinson, King's Counsel, the Commissioners, Director Mr. Jose Griffith, and the Commission staff for their steadfast work. Likewise, my lady, the Law Revision Department, under the capable direction of Dr. Camille Stoll-Davy and Ms. Karen Wade, continues its meticulous work to keep our legislation current and accessible. My lady, I extend my appreciation to the entire team of the Portfolio of Legal Affairs, including my finance and HR units. A team ably led by our Solicitor General and Chief Officer, Ms. Reshma Sharma, King's Counsel, and supported by her deputies, Mr. Jevon Alcock and Mrs. Marilyn Brand. Their commitment, professionalism, and resilience in delivering quality legal services on my behalf and across government and to me remain exemplary. Many thanks to the Director of Public Prosecutions, Mr. Simon Davis, and his dedicated team for their continued diligence in the pursuit of justice. I would also like to thank former Deputy DPP, Ms. Candia James, for her services over the years, and extend my congratulations to Ms. Nicole Petit on her appointment as Deputy Director. As always, my lady, we express gratitude to the Royal Cayman Islands Police Service, ably led by our Commissioner Walton, for their continued vigilance and dedication to maintaining public safety and law and order. They have been superb, my lady, and we take note that leading up to the Christmas period, they have been challenged, and, my lady, they rose to the occasion and allow us to enjoy a relatively crime-free festive season, thanks to the RCIPS. I would also like to extend my gratitude to Her Excellency the Governor, Honorable Deputy Governor, Honorable Premier, Honorable Leader of the Opposition, and all members of our National Security Council for their continuing vigilance, insight, dedication, and direction. Before closing, my lady, allow me to express appreciation to all members of the judiciary for their usual extraordinary work over the past year. Judgments were once again all well-reasoned, delivered efficiently, and to the highest standards. Our Court of Appeal, the Grand Court, summer courts remain as active as ever, and our rules committees continue to ensure procedural efficiency and responsiveness. My lady, I also crave your indulgence to note, with mixed feelings if I might say that my devoted colleague, Mr. Franz Mandison of Council, an extraordinary Deputy Governor, will be retiring later this year. My lady, he will be greatly missed, but his legacy will last forever. He has been the quintessential, dedicated, visionary, and impactful public servant who led the service with integrity and purpose. He has been a supportive colleague and friend of mine for more than 2 decades, and a person for whom I have the utmost respect and admiration. This will be his last attendance as Deputy Governor at this occasion, but there will be an opportunity later to say more at a later stage. So, more anon.
More anon.
My lady, in closing, I wish you, all honorable judges and magistrates, our court staff, members of the legal profession, our law enforcement officers, those present and those following online, a healthy, prosperous, and productive new year. May we continue to work together, unified in purpose, and steadfast in our commitment to justice, steadfast in our commitment to the rule of law, and for the betterment of these islands. If it may please you, my lady, I now move that the Grand Court be declared open for the year 2026. I thank you.
Thank you, Mr. Attorney. And please accept my thanks for establishing protocol. I was afraid if I continued to recognize persons, I would suffer yet another senior moment. The media is unkind to people who suffer those moments in public, as I think the experience in the North shows us. On both sides. I saw there was a stranger in my jury box, but I've been told it is Judge Howard, also here for the ABI conference, hopefully from further afield than Judge Mark. San Francisco. Is it cold? No. Well, then maybe you were not attracted by the fact that this was a midwinter escape. But we welcome you anyway, and hope you enjoy your time in Cayman. I thank you for your comprehensive address and for the overview you have provided of developments across government and the wider justice sector over the past year. I know everybody has listened closely. I associate myself with your tributes, including your remarks on the passing of Mr. Casey Gill. His contribution to the profession, to the islands, was both long and distinguished, and I also counted him as a personal friend. Of course, I associate myself with your tributes and your congratulations to Sir Anthony Smelly and his appointment to the Privy Council. That appointment was a fitting recognition of his exceptional judicial service. I associate myself with your remarks in respect of the DG, who has been not only an able deputy governor, but a true friend of the court. Although I had singled out Ms. Gloria for recognition, I'm often bothering the DG on WhatsApp and by phone, seeking his able guidance on matters of administration. For those of you who don't know, the Chief Justice is not much of a judge and far more of an administrator. And in matters of administration, I lean very, very heavily upon the DG's superior knowledge and his guidance. Join you in congratulating Mr. Merrin on his 50 years from call, which was in this court, I believe, last week. That's a good innings. We're glad he's still with us. With respect to the Legal Services Act, I also wish to underscore the significance of the full commencement of that act and the establishment of the Legal Services Supervisory Authority. The new statute, I think we may say, represents a generational shift in regulation of the legal profession and a major step in modernizing our institutional framework. And that is something which must strengthen public confidence while supporting the continued development of Cayman as a leading legal jurisdiction. I hope the members of the bar who have been invited to LISA's networking event take full opportunity to get to know Ms. Cheney and her team, because they will be playing a very important role in your professional lives going forward. And finally, well, not finally, I recognize Dr. Camille Davis Stowell. Stowell Davy, always get it wrong. That's another senior moment there. But she knows the esteem in which I hold her, and I recognized the breadth of the work of the Law Revision Commission this year. I think I owe you a response. And finally, Mitch Davis. Mitch, whose career, 30 years in teaching, one wonders how he survived it. I'm grateful to Mitch. He gave me the opportunity myself to teach. I spent 10 years at the law school delivering. I managed the tutorials in criminal law, to the distress of many of the lawyers who are present now, who passed through my hands, including the Premier. Yes, I enjoyed it. I don't know about them. I now call upon Mr. Simon Davies, our DPP, to second the motion and remind him that protocol has been established. Thank you, Mr. Bryan.
My Lady Chief Justice, I shall stand on that protocol, which has already been established by the Honourable Attorney General. My Lady, I second the motion of the Honourable Attorney General for the opening of the Grand Court, and I am grateful to my Lady Chief Justice for the opportunity to address the Court, and in particular to mention highlights of 2025, aspirations of the Office of the Director of Public Prosecutions for 2026, projects and plans to be executed, and also to comment on any initiatives to streamline the relationship which the Office has with other stakeholders. Before I do so, may I echo the words of the Honourable Attorney General, and in particular he has thanked a lot of people. I do not intend to thank them all again, so I echo what he's already said, and I will adopt his comments. As I move through 2025, it will also become readily apparent that some of the projects I mention are ongoing and will continue as aspirations and initiatives for 2026. So again, I do not intend to repeat them. I start my review of 2025 with our people, and they are at the heart of what we do in the office. And as with any organisation, there have been departures and arrivals. We thank those who have departed for their work and in some cases for their long-standing presence in the office over a number of years. The departures this year have enabled the office to build for the future. I am now privileged to have and to be able to work with an extremely strong leadership team. 2 new deputy directors, Nicole Petit, who has been with the office for 18 years, Barnaby Jameson, King's Counsel, a new assistant director, Poonam Chopra, and 2 senior Crown Counsel, Brian Treadwell and Martin Mulgrew. Barnaby Jameson, King's Counsel, is a globally recognised expert in terrorism and terrorist financing. He also has substantial experience of prosecuting drug offences as well as complex money laundering cases. His relationship with Grand Cayman accelerated after he prosecuted successfully 2 murder cases in this court in 2025. Poonam Chopra joins us after spending 3 years at the British Embassy in Washington, D.C. as a UK Crown Prosecution Service liaison lawyer. She has substantial experience in international mutual legal assistance, extradition and counter-terrorism. Her expertise will be invaluable to the Cayman Islands as the jurisdiction moves up the gears in its 5th round of mutual evaluation for, and here comes the first acronym, FATF purposes. I know how your ladyship does not like acronyms.
Only when I don't know what they mean.
Financial Action Task
I know
Force.
that one.
Good one. It will repeat it again. As those new members join the existing leadership team, I now have the opportunity to drive forward a number of long overdue strategic aims of the office. In addition, we welcome Nicosia Lawson to the team. She joins the international and financial team. Nicosia is a Cayman Islands attorney with over 10 years PQE. Prior to joining us, she was a senior associate at an international offshore law firm, and amongst other things, her areas of focus have been civil fraud, asset recovery, with specific expertise in digital assets. I thank our finance team and librarian for their continued hard work over the last year, and in addition, we would be lost without our dedicated HR team. And as has already been mentioned by the Honourable Attorney General, we must also reflect on the untimely passing of our colleague Colleen Williams, who was our HR manager. She was a stalwart supporter of the office and will be sorely missed. Staying with our people, I move to projects undertaken in 2025. In previous speeches, the legal family was a concept. It's now a reality. The legal family has been launched as part of what I understand will be a wider government job family. This will assist the office in driving recruitment of Caymanian legal talent, development and nurturing the skill set of those lawyers entering the office, as well as promoting retention. At its heart, the concept involves a significant volume of training and development. And while training developments are important, I'm also mindful of the fact that merely training people will not solve long-term retention difficulties. Training people well enough so they can leave is one thing. Treating them well enough so they don't want to leave is another. Quote from Richard Branson. The work-based learning scheme was also mentioned last year. That is now off the drawing board and is also a reality. It's well developed. 2 members of the office have been through the scheme. At its heart, the scheme promotes and develops the advocacy and forensic skills of newly qualified lawyers. This was an aspect of new qualification which I noticed was lacking. Other legally qualified employees, in addition to newly qualified advocates, have been introduced to the scheme for top-ups and refreshers. All of this points in one direction: succession planning and organic growth of the office. Raising the leadership bar and raising the bar generally is intended to expose young and newly qualified Caymanian talent to substantial experience, thereby nurturing development and retention. Staying with the office team, I thank the whole team for their dedication and hard work during 2025. They've all experienced substantial disruption in the office, and to their immense credit, have addressed daily problems with a smile and, I believe, have become more resilient as a result. 5 members of the team should be singled out for particular praise. Firstly, the first 3, Colleen Cummings, Sarah Lewis and Simon Spears, were the local organising committee for a conference hosted by the office in November. Their tireless dedication, energy and professionalism helped to make the conference truly special. The success of the conference was largely a direct reflection of their hard work behind the scenes, and the whole team are deeply grateful for the care and effort they put into every aspect of that experience. Then over the Christmas period, I should commend the conduct of 2 Crown Counsel in particular, namely Ben Brown and Stacey Ann Stewart, whose willingness to look after the office and the work of the office while others were with families and friends over Christmas was exemplary. 2025 was another busy year for the office in court. It received over 2,500 requests for charging decisions to be made. This is an increase on last year, with the last quarter being extremely busy. In excess of 140 indictments were preferred before the Grand Court, and in excess of 2,600 charges were filed by the office with the summary courts. Notable cases prosecuted successfully by the office included a murder case by the name of Rankin and Welcome. This involved a number of perpetrators zeroing in on a male victim as he slept, There were convictions and sentence has recently been imposed. George Senior, a shooting in broad daylight not far from this court, life imprisonment with a minimum term of 34 years, 8 months was imposed. Lindsay Watler, another murder case where the defendant was implicated substantially as a result of DNA findings on the deceased. Life imprisonment with a minimum term of 30 years was imposed. Operation Nassau is the case which we will probably all hear more about, a substantial case for the jurisdiction involving the importation of semi-automatic rifles, assault rifles, ghost guns and thousands of rounds of ammunition. It's expected that that case will resolve early in 2026.
Is that on the list?
Case of CE, this was a rape case where the defendant received a 12-year sentence, the victim was a 12-year-old child, and the case of YZ, another rape case where the defendant received a 16-year sentence, the victim again being an 11-year-old child. Hamilton and Salmon, defendants were charged with importation of fentanyl and being concerned in a money laundering arrangement, and each defendant received a sentence of 9 years, 6 months. A consecutive sentence was imposed for the money laundering charge to address totality. I mentioned child sexual exploitation. There has been a noticeable rise in cases involving child sexual exploitation. This increase will require greater capacity to ensure that appropriately trained Crown Counsel are in place to protect the interests of child and vulnerable witnesses. The worrying upward trend in this type of case is also something very much, I know, on the radar of this government. And in 2025, members of the ODPP have attended at and assisted the government in preparing for their involvement with the Lanzarote Convention, which is specifically designed to ensure that the jurisdiction has in place appropriate measures to protect children from such abuse. Complexity in casework is also on the increase. Whether it involves disclosure to do with numerous digital devices or consideration of cases involving, for instance, decentralised autonomous organisations. One wouldn't have thought one would be looking at cases like that in the Grand Court 10 years ago. The prosecutor must be resourceful and alive to issues beyond the commonplace. Recruitment of designated complex casework lawyers is the only way to tackle this technological complexity, especially where capacity is already strained to cover the work. I mentioned disclosure and the disclosure framework. Disclosure is also something with which the prosecutor has to grapple. One school of thought is that the criminal procedure rules presently treats the disclosure test as an aside. Outdated precedent which was decided at a time when kilobytes and megabytes of storage were en vogue is no good where we now face gigabytes and terabytes of data in one simple mobile phone. The criminal justice system cries out for an update to the disclosure framework in our respectful submission, where any one case can be immersed in millions of pages of digital data. For everyone working within the criminal justice system, the benefits of a structured disclosure framework with defence statements and disclosure management documents are multifold. Defence statements are one of the most powerful and misunderstood tools for making prosecutions fairer, faster and more effective. There is a myth that they are just a defence obligation. That could not be further than reality. They are a system-wide efficiency and justice mechanism. Digitisation. Long word, don't like it. Innovation, however, is not such a long word and is not an option for the prosecutor. Innovation is not an option for the prosecutor. I've been heard to say that too many times. I will continue to say it. I am passionate about the future prospects of the office having the capacity and the means to prosecute cases as technology advances apace. In September, at the recent annual International Association of Prosecutors conference in Singapore, I presented a workshop on means to educate the prosecutor, the judges, the defence and the jury in cases where artificial intelligence is used. I'm acutely aware of the benefits and advantages and potential dangers of AI. Without embracing the concept, we are in danger of being left behind. And it's hoped that appropriate funding can be put in place to develop an AI model, a prosecutor's AI model, to ensure that the office remains ahead of the technological curve. The Office has prepared well for digitisation. What was a concept is now a reality. This process has taken a long time. Systems are now in place for the Office to prosecute cases without paper. And while we are in a position to do so, others presently are not. We still receive regular requests for hard copy bundles of documents from some within the criminal justice system, and it's respectfully submitted that this reliance on paper, with bundles often involving thousands of pages, needs to end. I'll turn to strong relationships and collaboration across the criminal justice system. In collaboration with the Commissioner of Police, a monthly meeting at strategic level has been established to promote best practice between our two offices and wider across the criminal justice system. I'm happy to report that collaboration is strong, not just within the police service and our office, but with all law enforcement agencies and government departments. In addition, the office has provided training to the police service and a number of government departments. This has been consistent and relevant to what we do together, and that collaboration will continue. The last year has also seen closer collaboration with the overseas territories. At a meeting of the governors of the overseas territories in Miami, I presented a workshop designed to assist with a joined-up approach to crime detection and prevention. And following on from that, the Office has forged closer links with the Attorney General's chambers in Anguilla to assist them in developing their prosecution team. It's hoped that the DPPs of the OTs, overseas territories, can meet this year in order to share best practices, provide assistance to those who need it, and to develop a training programme across the overseas territories for lawyers. I also recognise that it's important for this office to get involved with the community. It gives the community the opportunity to see the face of the ODPP. And in the last few weeks of 2025, the office reached out to a number of entities to offer our assistance. This is charitable, it's voluntary. This outreach is to continue for 2026 and beyond. We've also developed our relationship with the Truman Bodden Law School and are moving this forward in 2026 with a number of engagements at which members of the office will attend. In addition, the number of internships offered by the office is increasing. This year, 4 Caymanian interns experienced life at the criminal bar from a prosecution perspective, and it's a sign of success when interns, one of whom's in the office as we speak, apply for return visits in 2026. We will continue to offer paid and unpaid internships in 2026 and beyond. Since September 2023, the office has been a signatory to the International Association of Prosecutors, the IAP. The advantages of membership are obvious. It gives the jurisdiction an international voice. It puts the office on the global map. It enables the office to measure success and best practice against its overseas counterparts. It also ensures that the office can monitor where it is with technological advancement. The IAP provides 2 webinars each month for the benefit of the office, and the majority of those webinars provide relevant training to the legal team. In addition, presence at the annual IAP conference in Singapore provided me and another member of the team ample opportunity to meet in person representatives from many jurisdictions around the globe. Where necessary, this was to establish relationships for international mutual legal assistance. We went there with 40 targets and had numerous fringe meetings across that conference. But more importantly, to develop and nurture existing relationships for international mutual legal assistance. By doing so, the word gets out that the Cayman Islands is open to assist other jurisdictions. The word also gets out that the Cayman Islands is serious in its commitment to tackling money laundering, countering terrorist financing, as well as the combating of modern slavery, human trafficking, drug trafficking, and organised crime. And our commitment to the IAP and to the global community went a step further, as I've indicated, in November, after our bid to host the 7th IAP Regional Conference for North America and the Caribbean was accepted. Delegates from the USA, Canada, Zambia, Gabon in West Africa, the UK, Anguilla, Bermuda, Montserrat, Turks and Caicos Islands, British Virgin Islands and Jamaica all join members of the office for what can only be described as an international melting pot of legal minds, all open to new ideas and best practices. The conference enabled the office to showcase Cayman Islands' leadership in prosecutorial innovation and standards. The office also had support in a number of ways from the Premier, the Honourable Andre Ebanks, the Honourable Attorney General, and Her Excellency the Governor, for which we are extremely grateful. As the central authority for the jurisdiction, I know how important it is to ensure that international mutual legal assistance is nurtured and developed. We process upwards of 10 new requests each month. We meet our foreign counterparts regularly over Zoom and ensure that we make the most out of opportunities to meet face-to-face at international events. Property freezing, civil recovery, production and restraint orders are the bread and butter of this department. Chasing criminal property, freezing it and repatriating it are key to an effective team. There have been notable successes this year, some of which are still to resolve. The Honourable Attorney General mentioned the Law Reform Commission, and I'm privileged to be a Law Reform Commissioner. I also enjoy my involvement with the Law Reform Commission as it celebrates its 20th anniversary and continues to groundbreak with regard to reform of legislation for the jurisdiction. I must mention FATF. Throughout 2025, members of the office have continued to assist the Honourable Attorney General and the government with preparations for the FATF fifth round of mutual evaluation. The office is inextricably linked to the FATF framework, and that support and assistance will obviously continue into 2026 and beyond. At the start of last year, I represented the Cayman Islands at the FATF Joint Experts Meeting in Vienna for terrorist financing, and that involvement culminated in a contribution to the update for the FATF publication on terrorist financing risks, which was published in the summer of 2025. Again in January, members of the office attended a retreat organised by the AMLSG Anti-Money Laundering Steering Group. In May, a member of the office attended virtually the Overseas Territories Countering Financing of Terrorism Forum. This was hosted by Bermuda, and that forum is funded and supported by the Foreign and Commonwealth Development Office in order to assist all OTs with their countering terrorist financing capabilities. In July, a member of the office attended the AGM for the Caribbean Asset Recovery Interagency Network, ARIN Carib, in Barbados. And after holding the presidency of the ARIN in the recent past, it is wholly appropriate to maintain strong links with and to support this organisation. In November, 2 members of the office attended the CFATF plenary in Barbados to assist the jurisdiction with its fifth round preparations. And also in November, further assistance was provided to the OT CFT forum, the workshop hosted by this jurisdiction. In the last 3 months of 2025, very busy 3 months, a number of the team were involved as working group members or co-chairs of working groups as the Office for Strategic Action on Illicit Finance drove forward the collation of risk profiles to assist it with production of the National Risk Assessment. Finally, for 2025, a strategy refresh. The office does not allow momentum to fade or become forgotten. In 2022, the office produced its mission and vision statements. With the influx of new recruits, especially to the leadership team, the office has been going through a strategy refresh to ensure that the direction of the office is sound and that our aims are deliverable. So, to 2026, the office has been going through a refit. I'll say no more about builders and dust. The whole team has had to relocate temporarily as this has been ongoing. And we thank everybody within the criminal justice system for bearing with us for the occasional lost file or whatever during the course of that refit. Over the next few weeks, the team will move back into an office which is designed to future-proof effectiveness, productivity and sustainability for the medium to long term. I thank the whole team for their goodwill and good humour as this interruption to their workplace has been ongoing. And with the new office comes more open space, more light, more connectivity, more effective digital capability, a larger and more comfortable breakout area, secure rooms for video links and sensitive calls, power, cabling and acoustics designed for digital work, a bespoke witness care suite, and a 25-seater training room designed for local and international connectivity. The goal is to turn the space into a tool which enhances the success of the office, and I would like to thank the Cayman Islands government for the capital injection which was provided to make this all possible. I know that the Cayman Islands government has sustainability and the UN Sustainable Development Goals well in mind. This is one area where non-legal goals of the Office of the Director of Public Prosecutions and the government strongly align. We all need to meet the needs of the present without compromising the ability of future generations to meet their own needs. SDG 16. In my view, one cannot achieve sustainable development generally if crime, corruption, trafficking, terrorism financing and injustice are allowed to thrive. For this office and for UN purposes, this is especially important. The office is not just a legal body, it is a core development institution. A strong prosecutor's office protects public funds from corruption, enforces financial crime laws, disrupts organised crime, protects children and the vulnerable, and maintains public confidence in the state. And in turn, the position of the Office of the Director of Public Prosecutions at the centre of the criminal justice system supports directly or indirectly for the jurisdiction inward investment, stability, international reputation, and social cohesion. In summary, I would suggest respectfully that this jurisdiction should treat prosecution capacity as a sustainability issue, not just a justice issue. Logic tells us that effective prosecution and justice capacity are conditions for sustainable development, not optional add-ons. So our initiative, Office Reconfiguration and Criminal Process Digitisation, seeks to modernise our physical workspace and digitise criminal justice processes. This dual approach is designed to enhance staff well-being, promote efficiency, reduce environmental impact, and strengthen access to justice in the Cayman Islands. The initiative demonstrates our commitment to sustainability, innovation, and justice. So by aligning with the UN Sustainability Development Goals, this project not only modernises our operations, but also contributes significantly to the Cayman Islands' vision of a sustainable, efficient, and equitable society. Part of that sustainability project requires the Office to embrace technology, as I've already indicated, and to stay ahead of the curve. Our intention, subject to funding, is to produce a bespoke AI model which will expand our capacity. With AI, artificial intelligence, I see we have two stark choices. On the one hand, a controlled prosecution-grade AI model, or on the other, an ad hoc use of external tools by staff. By the end of 2026, we should not be asking, do we use AI? We should be in a position to say that we control, and I emphasise the word control, a prosecution-grade AI model which protects justice, victims, and the public interest. Before closing, my lady, I echo the comments of the Honourable Attorney General in congratulating Sir Anthony Smellie on his appointment to the Privy Council. I would also echo his comments with regard to Frans Manderson, the Deputy Governor, or as I call him, DG. Publicly, I would like to thank him for all of the support and guidance he has given to the Office of the DPP while I've been there as the Director. I am positive that there will be another time for me to say more on that subject. My lady, I also wish to thank your court staff who assist daily with the smooth running of the court process for so many cases filed with the court by the ODPP, and I wish a safe, prosperous and productive new year to your ladyship, all judges and magistrates, the court staff, fellow members of the legal profession and those who attend today. And accordingly, I second the motion that this Grand Court be declared open for the year 2026.
Thank you, Mr. Davis. I have to say there were at least 3 moments when I thought you were going to yield. In summary, in closing, and just before I go, let me mention. But teasing aside, I thank you for your contribution and tell you that I am grateful as ever for the insight that you have provided into the work of your office and your plans for the future. I think it's important, and that's what this occasion is for. This is, I think, the only public occasion where you can stand before the public and say, this is what my office does. This is why we do it, and this is what we're doing next year. And so I am grateful for the insight you provided into the work of your office, your plans for the future. I commend you and your team for the energy and innovation that you continue to bring
Thank you.
to the work, to your commitment to strengthening prosecutorial capacity in support of the proper administration of justice. Can I just comment on what must be an extraordinary accomplishment, which was to steal from the private bar Nicosia Lawson to the public bar. People don't usually move in that direction, and so I think that is a feather in your cap. Congratulations on your conference last year, and I apologize again for not being able to join you. May I just, since you both mentioned your losses, the loss to your team of your HR persons, may I extend the judiciary's condolences on that loss. What you said about strengthening the prosecution is not as a matter of capacity but of sustainability applies to the entire criminal justice sector. And there will be an echo of it in my speech, which will be very short because I'm not being given much time left in the morning to deliver mine. But I think it's important to recognize that that issue of capacity affects every agency within the criminal justice system. And unless what I consider to be the lack of capacity and the lack of resources is addressed, there will be a very real issue going forward in terms of sustainability. How can we keep this model going if it is not properly resourced? Anyway, I thank you very much for your speech. In response to your comments about gigabytes, megabytes, things I don't really understand because I'm not a techie person, and the hundreds of thousands of documents in paper, which I do understand, the judiciary intends to lead this year on the introduction of a new document management system for trials. The system is called Case Center. It's from Thomson Reuters. Persons who do litigation will be familiar with it. Persons from England should be familiar with it because I think many courts in England have already using it. It will be first introduced in the criminal division of the Grand Court to enhance efficiency there. I think it will transform the way we work and the way trials are conducted. I think we will have some resistance from the criminal bar in the beginning, but I think with proper training, everybody involved in the system will appreciate how much having a dedicated document management module can assist in their own productivity. So we are negotiating with the providers right now to provide training, and we will timetable it after consultation with the bar. So thank you, Mr. Davis. I call on Mr. Barton, President of the Cayman Islands Legal Professional Association, to support the motion.
My lady, good morning. My lady, it is said that the brief shall be invited to speak once more. And since this is the first year of my second term, I will deem your remarks instructive. And so, in the usual theme of brevity, my lady, permit me to adopt the protocol so eloquently established by the Honorable Attorney General, and perhaps his entire speech, and take my seat. But given the industry invested by my counsel in reviewing this speech, it would pay them a disservice.
Yes.
My lady, I begin with our sincere thanks to you, not only as host of these proceedings, but in your capacity as chair of the Legal Services Council. Under your leadership, the full implementation of the Legal Services Act has been approached with care, inclusiveness, and a firm commitment to both public interest and the integrity of our profession. We also extend our appreciation to the former Chief Justice Sir Anthony Smelly KC, former Premier Sir Alden McLaughlin KC, and the former Leader of the Opposition, the Honorable Arden McLean, as he was then, credit to whom ensured that the Legal Services Act was more than stress tested. My lady, our sincere thanks also to the Honorable Attorney General and his legislative drafting team, and in particular, Ms. Karen Stephen Dalton, for their exceptional commitment in bringing the LSA to life. Equally, my lady, we applaud the current Premier, the Honorable Andre Ebanks, MP. My lady, I pause here as I reflect on a quote from the late Steve Jobs, co-founder of Apple, who once upon a time said, "The ability to lead is the courage to say no to great ideas." And as attorneys, we are operating under the false pretense that every idea that emanates from our mind is one that is good. I have failed to disabuse many of my colleagues on the opposing side that that is just a myth. My lady, our Premier is to be applauded for his decisiveness, his courage, and his ability to lead in the presence of great ideas. And I applaud him for his exceptional ability to do so in a climate that we have grown unaccustomed to. Yep. My lady, we also pay a special thanks to the current leader of the opposition, the Honorable Mr. Joseph Yu, MP, and the government for implementing the remaining parts of the Legal Services Act. Their efforts have helped ensure that this jurisdiction not only keeps pace with, but in many respects leads the global charge on anti-money laundering and best practices. I also wish to thank the members, past and present, of the Legal Services Council, Ms. Gina Ebanks, Mr. Stephen Watler, Mr. John Magoo, for their continued service, and to offer also my profound congratulations to the highly distinguished member, Mr. Orin Merrin, who this year celebrates an extraordinary 50 years at the bar. My lady, I say this without risk of contradiction, that every single meaningful legislation within certainly my career has the DNA of Mr. Merrin on there. And to him, we owe massive credit. My lady, this year, I wish to devote my brief remarks to chronicling the role that SILPA has played since its inception in 2018 in strengthening Cayman's AML and regulatory regime. From inception, Mr. David Collins, the first president and original council, which comprised of Ms. Wanda Ebanks, Mr. David Rich, Mr. Alistair Robertson, Mr. Klein Glidden, Mr. Eric Bodden, and me, understood that the credibility of our financial services industry would depend heavily on a robust AML framework. Since then, SILPA has worked closely with the government and the various regulators as the anti-money laundering regulations were modernized and strengthened. Its leadership played a key role in building and supporting the Cayman Attorney's Regulatory Authority, otherwise known as CARA, which undertook risk-based AML supervision of law firms and sole practitioners. Through CARA, led by Ms. Claire Guile, SILPA drove intensive outreach, filed inspections, and offered training during a period that spanned both heightened international scrutiny and the unprecedented disruption of the COVID-19 pandemic. My lady, as an inception member when Mr. Collins was at the helm, and in the presence of the stalwarts such as Mr. David Rich, Ms. Wanda Ebanks, and Mr. Alistair Robertson, in the words of Mr. Rich, he will not forgive me for stating publicly, we will long see such a dream team in our midst. And they are truly, along with the Honorable AG, the architects of where we are today. For them, I am eternally grateful. My ladies, since then, we have contributed to the completion of the FATF action plan, and played a key role in the jurisdiction's successful removal from the FATF list of countries under increased monitoring and from the European Union's AML list. These milestones were not abstract diplomatic achievements. They directly affected how our clients and counterparties view the Cayman Islands as truly the preeminent forerunner jurisdiction in financial services. Mr. Eric Bodden succeeded Mr. Collins and as president carried the momentum forward. Along with the LSC, Mr. Bodden was instrumental in laying the foundation for the transition from CARA to the Legal Services Supervisory Authority as the regulator with responsibility and oversight for AML supervision in the legal industry. Since 2023, under my leadership, SILPA has continued this trajectory in partnership with the government, the LSC, and LISA as regulators. During my tenure, SILPA has completed the transition from CARA to LISA, the dedicated body now tasked with maintaining the register of law firms and sole practitioners, supervising compliance on a risk-sensitive basis, issuing AML guidance to the profession, and where necessary, taking enforcement action. SILPA, thanks to Mr. Nick Bullmore, in close partnership with LSC member Ms. Gina Ebanks, has contributed to the development of the legal sector's code of conduct to ensure that AML responsibilities are properly integrated into our professional standards. We participated in consultations on what were the remaining provisions of the Legal Services Act, and we continue to engage stakeholders on aspects that require further analysis to ensure that regulations of our profession remains both effective and proportionate. My lady, I am grateful to the Honorable Attorney General for his involvement in this process, and I would caution the industry that the carts are loaded and the tracks are in motion. And so any discussion must bear in mind that not all ideas is worthy of being on board. I underscore special thanks to Mr. Stephen Watler and Mr. Eric Bodden, who have truly dedicated immense time in this regard. In closing, I express utmost gratitude to our members for entrusting me with another term as president. I am particularly grateful to my council member, Ms. Sophia Scott, my vice president, Ms. Kendra Foster, her predecessor, Mr. Nick Bullmore, Mr. Klein Glidden, an Inception member, Mr. Justin Hart, and Mr. Eric Bodden, also an Inception member, to whom I especially owe deep gratitude for his sage counsel. With their support since 2023, SILPA has delivered, my lady, free legal research platforms for members and sole practitioners, along with firms with less than 5 attorneys. We have facilitated multiple guest lectures, as with the most recent Family Law Conference held in 2025. We have launched several social networking events. We have established a properly constituted and democratically elected criminal defense bar, very ably chaired by Ms. Prathna Bodden, along with her deputy chair, Mr. Benjamin Tonner KC, Ms. Amelia Fossahini, and Ms. Candia James Malcolm. My lady, the composition of the criminal defense bar needs no room for improvement. My lady, above all, the full implementation of the Legal Services Act undoubtedly marks the most significant milestone, and perhaps in my entire career, following the commencement of which instantly reduced practicing certificate fees by half and waived the need for operational license fees for firms with under 15 practitioners. My lady, this is a leap into the future and levels the playing field for sole practitioners and smaller firms. And for that, I am very, very grateful. SILPA has already begun to engage leaders in the insurance sector to further assist with access to affordable professional indemnity insurance, and will make this a key priority, along with AML sensitivity training in conjunction with LISA over the next 2 years. I pause to congratulate Ms. Shanna Donovan as head of LISA, and I look forward to continuing the groundwork already laid in this regard. Finally, my lady, on a more somber note, we too at the bar mourn the tragic loss of Mr. Casey Gill, former colleague at the bar and founder of CS Gill & Co., and Sir Peter Cresswell, former judge of the Grand Court of the Cayman Islands. May they rest in peace. It only remains for me to thank the Honorable Attorney General for moving the motion to open the Grand Court for the year 2026, for which I am honored to second once more, and to take this opportunity to wish you, your ladyship, the judiciary, court staff, and my fellow members of the legal profession a very happy, prosperous, peaceful, and productive new year. May it please you.
Thank you, Mr. Barton. You've covered a lot of ground, and I'm afraid that my remarks in response have to be short, given the hour. But I would say you've made mention of the work undertaken by myself and the Legal Services Council in bringing the Act into effect, into operation. Making it law is not enough. The Act has to be operationalized, and that has been done with the Council, and I thank all the members of Council, and I will say especially Mr. Watler, who did an extraordinary amount of lifting when it came to transitioning from CARA to LISA. Without that transition, we could not properly have brought the law into force. And so I really do have to, as you just did, call out his exceptional contribution. And this is not to say that we're not grateful for the efforts of the other members, myself included, John Magoo, Mr. Marion, Gina Banks, and the AG. But Stephen really did some heavy lifting, and that has to be acknowledged, I think, openly. The other side of the Legal Services Council was the establishment of the Secretariat within the court campus. Now, because of the swiftness with which the law was brought into force, and I make no criticism, I think I agreed, the Secretariat has been established on the fly, or on the hoof. It is not staffed, but in the interim, the Clerk of Court and her team have been doing the work of the new Secretariat. The clerk was hitherto responsible for practicing certificates, enrollment, recognition of law entities was for the AG's office, issuing of operational licenses was for the clerk, and these things are now for the Legal Services Council, managed by the secretary and her team. So I'm very grateful to the clerk. I'm going to really call her out. She's unaccustomed to it, but I really must call her out and say that the work in establishing to making the new law operational was really led by her. It was necessarily collaborative, but led by her and her team. She has been appointed secretary to the council in the interim, and this ensures that the statutory framework was implemented with minimum disruption. I acknowledge her effort and thank her for the work she has done, and will continue to do until the newly established Secretariat is staffed and fully operational. And I think I would say just one more thing on that, which is that although I said the role of a Chief Justice is largely administrative, I'm still not good at establishing offices. And so I have asked Suzanne Bothwell, who is well known to all of you and has left the public service. I still drafted her back in a consultancy role to assist us in establishing the Secretariat fully, which is like developing operational procedures, establishing job descriptions, and everything else that it takes to fully fit out the office for not just onboarding lawyers from overseas, but assisting the tribunal, the disciplinary tribunal, when that one is constituted to hear disciplinary matters, to do the compliance, which is necessary under that statute. In the past, we issued practicing certificates, and that's all we did. Now, under the Act, there has to be a regular scrutiny of whether or not there's compliance with the certificate. It's a far more rigorous system under the LSA, and the clerk is not only not responsible for it, but could not, given the breadth of her work within the courts, take it on. So Mr. Zahn, and I expressed my gratitude. I called her and said, we need you. She was in my office within 5 minutes. What do you need? And her depth of understanding of process, offices, management, and of course she's a lawyer, what we need at this time. So welcome, Mr. Zahn. I have to acknowledge that there may be delays in responding to queries from the bar. Each query that comes into the clerk is forwarded to the council because we're still, as a council, deciding on our own procedure. And I thank everyone in advance for the patience while we build ourselves up to speed. So thank you, Mr. Barton. I congratulate Silpa, finally. So I'm the one finally to say in summary, I'm almost there. Finally, I congratulate Silpa on establishing an association of criminal defense lawyers who will make representation to the judiciary with one voice on matters of particular concern. So thank you for that.
My lady, I'm grateful. My lady, please forgive me. It would be remiss if I did not publicly acknowledge the unfortunate retirement of the Deputy Governor.
I don't think he would agree with that term, unfortunate. I think with the Deputy Governor, it's a welcome retirement.
Thankfully, he's not in possession of the mic this morning. But, my lady, it is incumbent, and I won't get into the detail this morning, but the Deputy Governor is one of the few reasons why I'm here before you this morning, and he's well aware of the citation, and to him, I am immensely grateful. May it please you.
As we all are. Thank you, Mr. Barton. Mr. McKee. The Public Accounts Committee? Cabinet. Right, well, as I meant to say at some point that certain members had snuck out while we were talking. That was the Public Accounts Committee. And now we see we have lost most of our audience now to Cabinet. Today was obviously poorly chosen as a date, and we will make sure that next year all members of the three branches can remain with us. Yes, Mr. McKee.
If it may please my Lady Chief Justice, protocol having been established, I am privileged to be able to support the motion to open the Grand Court for the year 2026 and to provide these brief remarks as consulting editor of the Cayman Islands Law Reports. We take this opportunity to look back to 2025 and to look forward to 2026. My colleagues at the bar have already mentioned the important changes that the Legal Services Act will bring about in 2026 and beyond. I propose to mention two aspects of that act. One, the mandatory code of conduct and the associated new framework for disciplinary proceedings, and two, continuing legal education. For many years, members of the Law Society and thereafter SILPA voluntarily agreed to be bound by a code of conduct. Insofar as it went, this worked well enough, but because membership of those bodies was not and is not compulsory, there was always a minority number of attorneys who were not bound by a code of conduct. In any event, the code of conduct did not displace the court's inherent jurisdiction over attorneys. The scope of the inherent jurisdiction was especially unclear because the English common law rules, mostly developed in the 18th and the 19th centuries, and thereafter were codified, enlarged, and abrogated by an increasingly frequent parade of English statutes starting in 1843. A further difficulty was that since 1875, the English profession had comprised two separate professions, solicitors and barristers, each with different statutory regimes and codes, whereas our profession is a fused profession. For our profession, clients, the wider public, and the courts alike, this was obviously a very unsatisfactory situation. The mandatory code of conduct is therefore most welcome. The now repealed Legal Practitioners Act provided only two possible sanctions against an attorney whom the court found guilty of professional misconduct: disbarment or suspension. Accordingly, disciplinary proceedings were only ever brought against attorneys who had a case to answer that, if the charges against them were proven, there was a realistic prospect that they would be at least suspended. If the impugned conduct of the attorney did not rise to that level, then all that could be done was for the Chief Justice to consider a reprimand or give advice as to future conduct. But that process of the Chief Justice was not a court process, and there was no public record of attorneys who had been reprimanded or advised as to their future conduct. Perhaps because of this, and of the relatively small size of our profession until this century, the number of disciplinary proceedings in court against attorneys between 1969 and 2025 were few and far between. The Legal Services Act includes sanctions additional to disbarment and suspension. If the disciplinary tribunal determines that an attorney has been guilty of professional misconduct, then his practicing certificate may be qualified to limit his practice of law. He may be fined up to 50,000 Cayman Islands dollars, be reprimanded, or be advised of his future conduct. Taken together, therefore, the mandatory code of conduct and the new disciplinary framework provides the opportunity to ensure continuing compliance by attorneys with modern standards for ethical conduct, and thereby to strengthen all stakeholders' trust and confidence in our legal profession. Nevertheless, there will be practical challenges in the years to come. Mr. Attorney has informed us this morning that there are 1,200 attorneys on the roll. That's over 4 times the number of attorneys that were on the roll when I first arrived in these islands in 1998. In addition, the Legal Services Act now permits lawyers working at the overseas offices of affiliated law firms to be granted general admission to practice, such as their offices in London, Hong Kong, Dubai, and elsewhere. I understand that the granting of general admission to overseas attorneys employed by affiliated firms may expand the role of attorneys by another 100 or more attorneys
400.
over the existing 1,200, necessarily ensuring compliance by the overseas attorneys with the Code of Conduct will represent challenges to the affiliated law firms who employ them and the new Legal Services Council, which will oversee the regulation, and the new disciplinary tribunal. The affiliated law firms, in coordination with the Legal Services Council, will no doubt implement internal protocols to ensure compliance by those overseas lawyers. Overseas attorneys who are granted limited admission will present a different challenge, because on limited admission, they are attorneys, they are subject to the same code of conduct and the same disciplinary mechanisms as the generally admitted attorneys. However, their principal practice is in their home jurisdiction. They are usually self-employed, and they are not employees of an affiliated law firm. Recent research suggested that the court had granted over 250 limited admissions over the last 5 years, mostly to KCs in London, and a few, but increasing, number of juniors. The number of limited admissions has been increasing year by year and across every area of practice before this court. In 2026 and beyond, the Legal Services Council will no doubt wish to consider appropriate regulations to ensure that those lawyers are also compliant with the Code of Conduct. On the matter of continuing legal education, the Legal Services Act provides, for the first time, a mandatory system of continuing education. The benefits of a profession that is, and is seen to be, reliably up to date with developments in our laws is plain and obvious. Nevertheless, implementing an effective educational programme will present challenges. Not only must the programme address our many unique and bespoke laws, but it must be able to deliver it to the 1,200 resident attorneys, the article clerks, and to those hundreds or more non-resident attorneys to be generally admitted at the affiliated law firms, and presumably to the 100 or so non-resident attorneys with limited admission. What I can say is that whatever challenges the new Act places before the profession and the Legal Services Council, experience has shown that we will be more than able to meet them. With that, I'll now move to the delivery of judgments in 2025. Our senior courts delivered 256 judgments as follows. In the Financial Services Division, 109. In the Civil Division, including appeals from the Summary Court, 33. In the Criminal Division, including appeals from the Summary Court, 62. And in the Family Division, 12. In the Court of Appeal, in the Civil Division, 20. And in the Criminal Division, 11. In the Privy Council, including applications for permission to appeal, there were 9 civil judgments and no criminal ones. I now report on the publication of the law reports in 2025. The second volume of the 2024 reports has been submitted to the printers for printing, binding and dispatch, and thereafter for uploading on the judicial website. For the judgments delivered in the first half of 2025, the judgments have been selected, the headnotes have been written, the copy editors and proofreaders have largely completed the task, and work on the various indices, tables, and cross-references will shortly begin. The selection of judgments from the second half of 2025 and the writing of headnotes for judgments already selected are both underway. Last summer, the judicial website reinstated a search engine for the online Cayman Islands law reports. We are very grateful for the efforts of Victor Villarin, the Information Services Manager at the courts, the editors and staff at Law Reports International, and the IT experts here at the courthouse for their sterling work in establishing this search engine. Before I leave the topic of legal publications, I am reminded that Professor Simon Cooper of the Truman Law School has published another very valuable work on Cayman Islands law, namely Inheritance Law and Practice in the Cayman Islands, thereby adding to the existing library of specialized Cayman Islands legal texts available to the profession and students alike. We thank you and the judges of the Grand Court, the President of the Court of Appeal and the Justices of Appeal, the Chief Magistrate and the taxing officers for your unceasing dedication to administer justice in these islands independently, fairly and efficiently. Much of that involves long hours out of court, such as preparing for hearings, writing judgments and ensuring the efficient administration of our courts. It would be remiss of me not to mention those persons who have given up their valuable time to act as acting Grand Court judges during 2025. They were Mr. Dale Palmer, Mr. Ben Tonner, KC, and Miss Kirsty Ann Gunn, as well as 2 who gave up their valuable time to sit as acting magistrates, namely Mr. Adam Roberts and Miss Suzanne Bothwell. We also wish to express our gratitude to the Clerk of the Court, who has also been our acting administrator for quite some time, and her deputies, and all of the administrative, technical, security and support staff on the court campus who, behind the scenes, work hard and diligently to serve and assist all court users. Before I close, I join my learned friends' tributes to the late Sir Peter Cresswell, who served with distinction in the Grand Court, in particular the Financial Services Division, and our late colleague and friend, Casey Gill. It now, therefore, only remains for me to wish a happy, healthy, and prosperous new year to you and all of our judges, magistrates, taxing officers, and clerks, to the entire administrative staff, to all members of the profession, and to the people of the Cayman Islands. I have the honour and privilege to support Mr. Attorney's motion this morning.
Thank you, Mr. McKee. I think your comments with respect to discipline of the bar and the adherence to our code of conduct by overseas attorneys who are here on a limited admission in particular cause or action are well noted. And I'm quite sure as the law matters are brought before the council and ultimately the tribunal, processes will develop. It's impossible to say now what challenges may arise and how they may be dealt with, but you certainly raise cogent points for discussion. Thank you as ever for your report on the law reports and for advising us on the number of judgments issued. Thank you for recognizing that the clerk, to whom I've already paid tribute, has also been for the last year our acting court administrator / chief officer. So she has been not only, she's continued in many respects to operate as clerk while also running the administration of our support arm, HR, IT, etc. facilities. And I'll come to that in a minute, the work that the administrative support has done this year to support the work of the courts and judiciary. Thank you very much. I accede to the Attorney General's motion to open the court for the legal year, and now it is time to add a few remarks of my own. And for our American colleagues, you might just have heard a State of the Union, or perhaps a state of the criminal justice system. You've heard one side of it, which is the position from the bar. I know you must listen to me give the position from the bench. It's a very lengthy proceeding. I hope you have found it instructive to date. As with you, Mr. DPP, I consider the people to be the most important part of what we do, those we serve and those who work with us. And so, like you, I open every year with the transitions. The opening of the new legal year is a moment that naturally looks in both directions. It is named after the god Janus, with his head facing in both, forward and backward. So, as is our custom, I begin by acknowledging those whose years of service to the judiciary have concluded. And I start with Mrs. Cecile Collins, who sits today in the jury box. Mrs. Collins retired in July of last year from her role of deputy clerk. She had responsibility for the criminal registry. Well, it was not her first role within the court. She can correct me from the jury box if she likes, but I know she held many, many posts, including personal assistant to judges of the Grand Court and listing officer, before her very long tenure as deputy clerk with responsibility for the criminal registry. In all, Ms. Cecile has 44 years of service to the courts and judiciary of the Cayman Islands. I cannot think of anybody whose service parallels her own. Long before knowledge management became a fashionable term, Cecile was a repository of information that might otherwise have been found only in manuals, handbooks, or databases. Standing operating procedures, institutional practices, the accumulative wisdom of how things were actually done in the courts was held by Cecile, and happily she shared. On a personal note, when I arrived here in 1998, I came from another court. I didn't have to be taught how to be a judge, but I did have to be taught how things were done in Cayman. And Miss Cecile guided me throughout, I would say, all my tenure on the magistracy of the Cayman Islands. She was a ready resource. The courts could not have survived without her. I say that even though we have survived without you. We have, but we miss you terribly. The Cayman judiciary were early adopters of electronic case management and acquired GEMS, which was back in the 90s? Back in the 90s was a sophisticated integrated system for filing, recording, and tracking cases, as well as generating court calendars and cause lists. So it was a modern case management system. But all case management systems have to be configured for your own jurisdiction. And one of the most notable things about Cecile's career as deputy clerk criminal was that she, with no formal training or background in IT, actually rebuilt or configured GEMS to the needs of our summary courts, because the Grand Court too is criminal registry was kept there. The systems that she put in place, the practices that she embedded, continue to shape the daily work of the criminal registry and form an enduring part of her legacy. So there you go, it endures. She once said she's going to leave and take her institutional knowledge with her. But we are so grateful to Ms. Cecile. Her contribution went beyond systems and processes. She understood the human demands of registry work in the criminal jurisdiction. I've often said in these courts, and for those who don't practice at the criminal bar, you may not know, but nobody who comes before the criminal courts are happy. They believe they have been wrongfully accused or wrongfully victimized, or their time is wasted, or they're vulnerable witnesses who are kept in a closet until they're called. Nobody who comes before these courts are happy. And she has supported a team comprising registry staff, marshals, and bailiffs whose work is front-facing, demanding, and often stressful, as you can imagine. Her Friday potlucks and her Christmas gatherings, games, and prizes were more than social occasions. They were acts of care for colleagues carrying some of the heaviest burdens within these courts. She is greatly missed. How many times am I going to say that this morning? She is greatly missed, not only for her knowledge and leadership, but for the steadiness, the generosity, and the good humor she brought to the life of the courts. I thank her for her service to the court, and we wish her all the best in her retirement. Thank you, Ms. Cecile. As we transition out from Ms. Cecile, I must welcome Ms. Sonia Nash-Stewart. She's hiding around the back. There wasn't enough space on the clerk's bench for her this morning. She is our new deputy clerk of court in the criminal registry. She's a graduate of the Norman Manley Law School and was called to the bar in 2016. She practiced at the criminal bar in Jamaica in the chambers of Wentworth Rocky Charles. And as the young people say, if you know, you know. She joined the public service in 2020 as clerk of court for the Kingston and St. Andrew Family Court, and then as senior judicial clerk in the Court of Appeal, clerking for Mr. Justice Frank Williams, who is well known to all of those here who practice in the criminal courts. He's frequently an acting judge in our criminal division. I have to say that the recruitment exercise had scarcely been completed by the time Mrs. C left office. There was no handover, and Ms. Stewart responded to the court's urgent need to fill the role in order to maintain continuity of service and commenced work almost immediately. The recruitment exercise was done. And she did so when her newborn child was barely 7 weeks old. That she did so to another mother-in-law speaks volumes about her sense of duty and commitment to public service. and I acknowledge it. On behalf of the judiciary, I express our sincere gratitude for her for stepping forward at what was a critical moment for the court with Mr. Seal's departure, and for the professionalism with which she has assumed her responsibilities. I turn now to a farewell of a different kind, marking the conclusion of judicial service by a member of the Grand Court, whose contribution has been felt well beyond the Financial Services Division, and that is the retirement of the Honorable Justice Ian Kawley last year. Justice Kawley was appointed a judge of the Grand Court in April 2017. He retired from office in August of 2025. During his time with us, he made a substantial contribution to the work of the FSD, bringing to the court deep experience in complex commercial litigation and a disciplined analytical approach to the resolution of difficult cases. Justice Kawley came to the Grand Court with a distinguished judicial and professional background. He had previously served as Chief Justice of Bermuda, following many years on the Supreme Court of that jurisdiction. Before his appointment to the bench, he had practiced as both a criminal and commercial advocate in Bermuda and England. His work in the Financial Services Division reflects not only that breadth of experience, but also his scholarly engagement with the law. That engagement is also evident in his editorial work on offshore commercial law in Bermuda and other publications addressing offshore commercial practice, to which I believe our Honorable Justice Doyle has also contributed. His judgments in the FSD are noted for their clarity, and they're frequently cited, reflecting both their significance and the care with which complex issues were addressed, and might I say, with humor. Almost in all of Kawley's judgments, there's what the young people call a little Easter egg, a reference to One Love or some other cultural anecdote. We thank Justice Kawley for his service to the Grand Court and for the contribution he has made to the development of our jurisprudence. We note with pleasure his appointment as President of the Court of Appeal of Bermuda, unsurprising, with effect from the 1st of January 2026. And we offer him our warmest congratulations on that distinguished appointment. You may know that before his formal retirement, Justice Kawley, who started with us as a part-time judge, I use that expression, before he became a full-time judge, transitioned back to part-time work before his retirement. And so when his retirement date arrived in August, he was not on island. So we never had our traditional valedictory ceremony to celebrate his leaving. But I understand he might be here at the end of the month to address a conference, and I'm going to see what I can do to arrange some sort of farewell to which the bar will, as always, be invited. I turn now to Her Honor, Mrs. Kirsty Ann Gunn. I would like to record our appreciation of Her Honor, Mrs. Kirsty Ann Gunn, who is leaving the magistracy to take up appointment as a circuit judge in England and Wales, deployed to the Northern Circuit with effect from the 2nd of February 2026. I hope she's had an opportunity to discuss being a circuit judge with Justice Emma Peters. Mrs. Gunn has served as a magistrate of the Summary Court since 2012. In addition, she has served as chairperson of the Planning's Appeal Tribunal for the Sister Islands since 2021 and chairperson of the Guardian Ad Litem panel since 2023. She was appointed to act as a judge of the Grand Court on several occasions between 2017 and 2025. She has been a solid and dependable member of the magistracy, and her colleagues will miss her support and wealth of knowledge. She had a long career before she came here, obviously, at the bar. And I think was with our own, I think it was called the legal department then. It wasn't the DPP's office. Was it the legal department? Yes, right. It's now DPP's office. So she was a Crown prosecutor went to Bermuda and did that there and then came back. We consider her appointment to the circuit bench reflects the caliber of judge she has proven herself to be. And we thank her for her service to the courts and to the islands, and we wish her the very best of luck in her new post. For the criminal bar and anybody else who might wish to say farewell to Ms. Gunn, a special sitting for Mrs. Gunn will be held on Friday afternoon in Court 2, to which all are invited to say farewell. I note the presence of her husband, Simon. I think this was the first time you've ever attended a legal year opening. We hope to see you on Friday as well, when there will be an official valedictory sitting to say goodbye to your wife, whom we all treasure. We thank Mr. Adam Roberts, is Adam here today, for agreeing to an acting appointment to ensure that the work in the Magistrates' Court continues smoothly until the recruitment exercise is concluded. We seem to be having a problem keeping ahead of our recruitment exercises. Finally, I extend a warm welcome to Justice Emma Peters. Obviously, she's been with us for nearly a year, but this is the first time she sits with us at the opening of the court, and it is the first of what I hope will be many opening ceremonies. Justice Peters joined the Grand Course in February, following a rigorous open recruitment exercise conducted by the Judicial and Legal Services Commission. You have heard from one of our speakers, I forget who, of her extensive judicial experience from the UK, including distinguished service as a circuit judge and a deputy resident judge. But she wears bars this morning. I didn't get a chance to ask her, on her robes, which I think are unassociated with her work on the bench, but rather her judicial and legal work with the British Army. Does she agree with that? Yes. She's the only one of us who has medals. We're all envious, and we're really pleased to have her. She's also a bencher of Lincoln's Inn, for those who know. That is a mark of recognition by the inn to which you are called. We're very pleased to have her on the Grand Court and look forward to her contribution to the work of the Grand Court. In memoriam, we of course remember Sir Peter Creswell. We posted our tribute on our website last year. He was one of the earliest members of the FSD. His contribution to the development of Cayman's jurisprudence, particularly in the formative years of the FSD, is deeply appreciated and remembered. Now, I'm going to have to cut my speech down. You don't have too long opening State of the Union addresses. So I'm going to speak to matters that occurred in the last year, which I think affected the public a lot and court users. And I'm going to skim over, and I'm saying this for the media's benefit, a recitation of numbers in the courts, as those numbers have been referred to some extent by Mr. Davies in crime and by Mr. McKee when it comes to recording of the number of judgments issued, as I try to not wear the patience of what has been an extraordinarily polite and attentive audience. The year 2025 was marked by a period of significant operational change across the law courts, which required careful management to ensure continuity of service and the effective administration of justice. Those of you who come to court will be aware that substantial works were undertaken in this main courthouse to improve facilities, including long overdue renovations to the criminal registry to improve the working environment for staff. And also, Mr. McKee will be happy to hear, the completion of certain accessibility improvements, such as wheelchair-accessible restrooms. These works were aimed at removing physical barriers to participation in the justice system and form part of a broader program upon which the judiciary is engaged at improving access to justice in the hope of increasing public trust and confidence in the courts. Further preparatory works were carried out in Courts 1 and 2, which are not obvious to you, but they were carried out in anticipation of the transition of these two courts to fully digital courtrooms. So we have done all the necessary, I'm not a techie person, but all the wiring that goes under the floor. So the microphones now don't thread across the carpet, but come from the floor. We have new speakers. We're not using them today. We're still using our former provider for these services at the opening. But we have new speakers, new microphones. We have tablets for the jury. The judge has a new suite of microphones and screens for the bench. In advance, Mr. DPP, of the introduction of Case Center. So this was one of the renovations I had promised to give life to our continuing commitment to digital transformation in the courts, which is making all the courtrooms fully digital or have full digital capacity. People are harder than courtrooms to change. So while we have wired the court to become a fully digital court, it remains to be seen whether we can get the lawyers to adapt. I'll have to make it, I think, a matter of the code of conduct. You must learn to conduct your matters electronically or you commit an offense. The legal aid office was also relocated last year. Although the office is managed by the judiciary in the sense of we provide it with all the ancillary services, including finance. They don't have their own accountants, we provide that. We still want to give that office a sense of autonomy, and the people who use that office a sense that the office is truly independent of the courts and any parties. And so they're now at Artemis House, and they were relocated with minimal disruption in service. The move required actually running a cable from the main courthouse here all the way down there so that they could securely access our database. I asked the IT man, so when I move the FSD to Camana Bay, are you going to install a cable all the way down there? He mentioned acquiring something called a VPN. None of this makes sense to me, but I'm very pleased, at least in one regard, that the IT department is content that the legal aid's continued access to the court's e-platform does not pose a security threat to the court itself. I acknowledge the exceptional teamwork by our facilities team and the IT team, both the members of the team and how they work together, because these projects have all been brought to a successful conclusion in what must be record time. I've just listened to Mr. Davis tell me he has been trying to fix his office for the last, 9 months? And we have done extraordinary works in this court, including, as I said, retrofitting these courts to become fully digital, redoing the entire criminal registry, a new tiling throughout the building, and a complete refresh in the few vacations that we have. I do apologize to my colleagues Richards and Peters because there was some apparent disruption in court from errant drilling on the floor below. But as soon as it was brought to my attention, I wrote the facilities team and told them not even the court administration was allowed to disrupt the proceedings of the court. So I do thank them. I also thank the judges who preside in this courthouse, the court users who attended before them, for their patience while the works were sometimes audibly underway, as well as all the staff who were dislocated during the renovations of the criminal registry. They all set up temporary offices in the law courts at Cardinal Avenue. What's that building called again? The law courts at Cardinal Avenue. The renovations were long overdue and were given a priority as it was part of the judiciary's strategic objective of increasing employee engagement by creating workspaces that reflect the judiciary's values and its commitments to investing in our people and making them feel supported and valued. Right? The space you work in is necessary to feeling that you are a respected member of a team. Last year also saw a major transition in court operations with the implementation of the Curia case management system within the criminal registry. This was the last registry to be migrated to the criminal, to the e-platform. So the Curia system to which it has been migrated doesn't just only provide newer e-litigation portals and greater functionality. The fact is that the original system, GEMS, it died. There was no time except to move. So I'll tell you the story. The transition took place against a backdrop of significant personnel changes, which was started by the departure of Ms. Cecile. So just on the eve of transferring her bespoke criminal registry in GEMS, the one that she built, to a new registry she had left. And there were other significant departures within the criminal registry at the same time. So against a backdrop of significant personnel changes, you had the GEMS failing. It has been in use since 1998, which is good enough for any system. It no longer has developer support. And we had reached a point at which continued operation was no longer viable. And so the circumstances necessitated an accelerated implementation timetable. So words like change management, just didn't apply, because change management suggests that you have time to explain what's happening, train the necessary parties, let the public know what's going on, keep everybody informed. It's usually a process. This was something so immediate because GEMS was collapsing. It had kicked off several users from the platform. And we had to do an accelerated implementation timetable. So there were missing court lists and occasional missing files. But as I said to Mr. Davis, I don't recall that Rome was built in a day. And so I will say this, that despite the challenges, the transition was successfully completed, and now all registries in the court are operating on the new Curia case management system. This represents a major institutional milestone. We are ahead of most courts in the region in having a case management system for every registry of the court. The pace of change, I accept, resulted in temporary gaps in service, but these issues have been resolved, and I give, for the third time this morning, credit to the clerk of court, who was tasked with overseeing the implementation of the system and the training of staff, as I said, in a rough and ready way, because the idea of a change management process over months was just not possible. And I also give credit to the new deputy clerk and her registry team, because they maintained service delivery throughout what was a very demanding period of change. The support of the magistracy was also critical in ensuring that court business continued without interruption, although I understand the chief magistrate called downstairs several times in a day to demand her files. I understand that there are still some issues. Certainly for this morning, I was unable to pull from the new Curia system the disposals so that I could inform you as to how many cases had come in and how many had gone out. I'm unable to do that this morning because of the transition. But all things in time, I think at the end of the day, we will all recognize the benefit of the new electronic case management system being extended to crime. So alongside those operational changes, we strengthened our workforce. We were able to complete several recruitment exercises to bring in new staff into the organization to support capacity during that period of transition. So in my view, despite the criticism which has come to my ears, and that's okay, we're never shy of being told what's not working. If you don't tell us what's not working, we can't fix it. But I say this, that despite all the struggles that the bar experienced, that court users experienced, that the magistracy experienced during this period, I consider that the events of 2025 have demonstrated the resilience of the institution and the professionalism of our staff. And I look at the DG when I say that, because these are indeed world-class civil servants working in the third independent branch of the state. Despite the scale of change experienced during the year, core court functions were maintained. Important foundations have been laid for further reform, and I prefer to focus on that than on what has not gone well. I now turn to look at the business of the courts. As I said, we're still in transition, so I'm not going to report on the criminal statistics because they will not be fully accurate. Mr. Davies has given statistics which the media may find interesting. The disposal rates are important because the case clearance rate, the KPI, that's a key performance indicator for a court. One of them is the case clearance rate. Cases in, cases out. 100 cases in, 100 out, it means that your court is keeping up with the workload. 100 cases in, 120 out means the court is making inroads on a backlog. 80% out, and the court is creating a backlog. I shouldn't say creating, we don't create anything. We're demand-led. We only do as much work as comes to us. But if we can't keep up with the volume of work, so the case clearance rate falls below 100, then we all know there's an incipient backlog. So we keep track of these figures as we do time from intake to disposition. But I'm unable, as I say today, to give you those rates. What I can tell you is this, that the 140 new criminal cases that were filed, while it is a figure broadly consistent with last year, it is still a figure 40% higher than the entire period, 3-year period before that, say 20 to 23. Standing alone, this figure does not permit conclusions to be drawn as to the cause of the increase in cases before the court. And that is to say, whether there's been an increase in crime or an increase in detection of crime. We're not quite sure. We don't speculate as to the reasons for the increase in cases filed. But I can say this. Experience has shown that increases in enforcement activity, if not matched by a corresponding investment in the capacity in the courts, at the bar, and the supporting agencies, Mr. DPP, will inevitably place additional pressure on case progression and remand. So as I said, we continue to monitor our clearance rate. But in the absence of having complete figures, what we did do this year was we undertook a detailed review of persons on remand pending trial. Because another KPI, key performance indicator, is that persons who are before the Grand Court and are in custody are tried within 6 months. So we did a review. I thank my sister Richards. We did a review of persons on remand pending trial against that benchmark of 6 months to see how many of those were within the 6 months, how many of those were outside, falling outside and were delayed. Now, as at 6th of January, there were 38 defendants on remand to HMP Northwood from the Grand Court. Only 12 of those cases, that's a good statistic, only 12 of those 38 cases have actually extended beyond the 6 months benchmark, right? Only 12. And our review demonstrated that the principal causes of this extended remand for these 12 people were not judicial inactivity, wasn't a failure to list trials effectively. There were capacity constraints elsewhere in the criminal justice system, most notably delays in the preparation of pre-sentence and mental health reports, limited availability, Ms. Prathna, of defense counsel in serious criminal cases, and in some instances, delay in receipt of expert reports from overseas. We send we do get GSR reports from external agencies. So the reality bears stating plainly. The progression of criminal cases depends on the timely engagement of multiple agencies. Where reports cannot be prepared, assessments can't be undertaken, counsel are not available to proceed, cases cannot move, regardless of how many judges are available to sit. I have stopped clamoring for more judges. More judges would create more persons on remand, more backlog, which is a sort of counter idea. It seems counterfactual. But because we don't operate in a silo, that is necessarily true. This is why I established, I think last year, a criminal justice stakeholders working group. I hope it hasn't been superseded by the DPP's own group. But the idea of this group, I'm teasing, the idea of this group was that we would consider together what were the constraints in the system at large. You can't focus on any one office. And then make representation to the cabinet and to the executive through the AG, who is supposed to be a member, so that the matter could be raised formally with the governor and cabinet. Because it is a matter of, what do we say? I won't say it's a parliamentary will, but it is a matter of where we choose to place our resources, in other words. So when I say, and if social services or the Department of Community Rehabilitation is listening, this is not a criticism. You're talking about, goodness, 147 people in the Grand Court. There were 2,000 people before the summary court this year. Our standard is to apply for reports in most serious cases. Our summary court is inaptly named. They hear serious offenses, burglary, importation of drugs, indecent assault, cases that require consideration before they're sentenced. It is impossible to imagine that reports could be prepared for those courts by what? A small contingent of 15 or 30 persons? Mental health reports, we rely on the HSA for those. In one case, we waited 8 months for a report. I make no criticism of the person within the HSA. There is a massive demand for these services, and frankly, there's insufficient people to fill the demand. That's really what it is. It's not a question of finger pointing or laying blame. It just bears stating plainly. The progression of criminal cases depends on the timely engagement of multiple agencies, all of whom, I can tell you from my criminal justice working group, all of whom have severe resource constraints. Okay? I mentioned the criminal bar again. Can I just say I joined this court in 1998. And to my certain recollection, Sir Anthony, Chief Justice Smelly, as he was then, said every year that there was a shortage at the criminal bar. And we were only 400 lawyers then. And even now with 1,200 lawyers, there is still a shortage at the criminal bar. That's because it's not as interesting a place to work as a funds desk in one of the other law firms. But Smelly, in 1 year, and the AG can rise and correct me, I forget what year it was, issued an invitation to the larger law firms, the Walkers, the Maples, to consider hiring into their cohort one criminal barrister, just one, who would come and assist the court. We got several. Mr. Tunner KC was one of those, and there were several others who came, and it was a brand new day in the Cayman courts. I think they came, Mr. Tunner can remind me, I think from 2000 on. But it was certainly a great assist to the court. That experiment by the law firms has never been repeated. I can well imagine that they found very little reward in the public service of hiring a lawyer just for the purpose of assisting the criminal courts. But it is one of the largest, I think, contributors, if any, to delay. And this again is said without criticism. I've spoken of Prasna before, and I would just say I commended her at the end of the year for increasing the complement of Samson Law by 2. Turns out my congratulations were a bit premature, because she only increased it by 1, as one of the lawyers went on rollover. So we're still short. But on that topic, I bear in mind what Mr. Barton said, which is that the fees for small firms having been reduced is an opportunity for the small firms to grow larger. And so I encourage the smaller firms to, who do criminal work to increase their numbers. But I don't want to belabor the point, but the experience of 2025 reinforces a central point, which is that the courts do not operate in isolation. Anyway, notwithstanding these constraints, the Grand Court, as usual, has taken steps to maximize the effective use of resources. And later on in this year, with the agreement of the bar, we'll be sitting 3 criminal courts in tandem to address some of the outstanding matters. It has to be with the agreement of the bar, because we have to be sure that when we bring an acting judge to the jurisdiction, that his time is not wasted and that he can hear matters. I take this opportunity on behalf of my sister, Cheryl Richards, to record the importance of the contribution made by members of the public who serve as jurors. They are hardly ever mentioned at the opening. Their willingness to undertake this civic duty, often at personal inconvenience, is essential to the proper functioning of the criminal justice system, and the courts are grateful for their service. But might I add a rider to my sister's note of thanks, that it may become time to consider ways in which we could increase the number of persons eligible to serve. I will say no more than that. Moving to the FSD. 371 cases commenced in the FSD this year, which is basically on par with other years. Of those, 169 were applications to restore companies to the register. These are administrative applications also dealt with by the clerk of court. I sometimes think the breadth of her engagement is not understood. Of the remainder that were assigned to judges, these included 125 petitions for the winding of companies, 31 originating summonses seeking various types of relief, including relief under the Trusts Act, and 31 writ actions. 218 matters were closed, and as you've heard from Mr. McKee, the judges of the FSD delivered 109 written judgments. Now, this is significantly less than the 146 handed down the year before. But can I say, if any of you ever browse our website, what was lost in number of judgments was made up for in length, as several decisions spanned hundreds of pages. But those were delivered in complex matters, some of which occupied the courts for weeks at a time, and included tens of thousands of documents. I myself presided over a case in which there was the disclosure was over 1 million documents. And whilst nonetheless impressive, the sheer number of judgments delivered, or the sheer length of them, does not fully reflect the activity of the judges in the division, as they made many more orders in interlocutory and final applications, which did not call for a formal judgment. On the online version of this report, I list a small selection of what we consider to be important cases handed down by the FSC last year. In the civil division, we had 262 new civil matters, down from 287 in 2024. In the same year, 120 matters were disposed of, 33 judgments were issued, and 800 orders made. And I've started to count the number of orders, and next year I'm going to start counting the number of days sat, because a mere recitation of judgments delivered does not express the actual work that is being done by those courts. 800 orders means that there were 800 hearings in which a decision or order was made. Detailed information on the days sitting in the civil division is reflected in the published cause lists, which are available on the court's website. Taken together, the lists demonstrate, in my view, a consistent and sustained pattern of civil sittings throughout the year, belied, I think, by the number of judgments. I think the notable cases in that division, which will also be in the online report, would include the several judicial reviews of public interest, most notably the National Conservation Council and the Central Planning Authority, which was reported in last year. In probate and administration, 223 new matters were filed, 205 probate and administration grants were made for a clearance rate of 91%. Can't complain about that. In the family division of the court, well, my brother says he experienced another exceptionally busy year, characterized by not only by a high volume of new filings, but by the increasing complexity and persistence, where's Richard? Persistence of contested proceedings. Now, you know we're fans of mediation. So when he speaks about the persistence of contested proceedings, it is really a complaint of people preferring to use the judicial system. I have to be careful how I say this, but the system should not be used to beat your opponent. And in divorce cases, it starts to feel like the parties are opponents rather than formally married persons who very often share children. And so we would like to see mediation used more effectively. The damage to the relationship, it doesn't matter that you're divorced, you should still maintain a relationship going forward for the benefit of the children. So these scorched earth trials are really not helpful. And this is what he means by the persistence of contested proceedings. By that, too, he reminds me that he has had matters which have been contested, been decided, and been brought back to the court. As he says here, the division has had to encounter unusually lengthy contested child cases, which place a disproportionate demand on limited judicial resources. One such matter, which had already occupied 30 contested hearing days within a 12-month period in 2024, required a further 8 days of hearings during 2025 to address renewed disputes between the parties. As he notes, where there's only one permanent family judge, we do assist in that division. But when there's only one division head, the impact of cases of that nature on availability of court time for other families is significant. He's not speaking of the impact on his own workload. Let me say that again. The impact of cases of this nature on the availability of court time for other families is significant. It means that somebody else's matter is not being resolved because disputants are taking up perhaps what might be considered a disproportionate amount of time. Now, as I said, we had hoped for greater use of mediation, but we noticed that in the last year, there was an increasing number of matters being returned to court from mediation, not being resolved regrettably. Reports in the mediation department indicate that in some cases, parties, and regrettably, at times, the parties' legal representatives fail to engage constructively with the mediation process at an early stage. And that has resulted in a concentration on contested matters returning to the court within a short period, requiring intensive case management and increasing interlocutory and substantive hearings. That said, hands-on judicial case management has enabled a number of these matters to be resolved without the need for full hearings, with the judge himself adopting a sort of mediation-style approach to the matters when they come in front of him. But as he notes, this approach, while effective, is resource-intensive and further illustrates the pressures placed on the division. I would just say that it was in response to concerns like these that we indicated last year we'll be having a family law conference. It is somewhere in the rest of my report, but I'll just deal with it here. We had the conference. It was a tremendous success from the feedback we've received from the bar, and I thank everybody who was an important part of making it happen. Of course, you know that the distinguished guest lecture was led by Sir Nicholas Mustin, who also participated in the family law conference, which came rapidly behind. I will not deal with the appeals court. You've heard the numbers in and out of the appeals court given by Mr. McKee, and you will be aware of the number of cases from the jurisdiction that were decided by the Privy Council. For those who are interested in legal scholarship for its own sake, I invite you to read the Privy Council judgments. As Lord Reid himself has said, Lord Reid, the President of the Privy Council, himself has said, that the cases they see from Cayman are among the most important cases that they decide. So the work that they do arising from Cayman cases have international commercial impact. Now, given the time, I am not going to read the report I received from the Chief Magistrate, only to say, as I've said, that that court continues to deal with a vast amount of new matters. There was an 88% increase in criminal case files, a 44% increase in traffic summonses. That's not the same thing as tickets. Those are matters that the magistrates have to hear. There was an increase in the number of youth court matters. There was an increase in private and public law child matters. Without having the figures to hand, because I don't, I know that their case clearance rate is not what it has been in the past. But again, I have spoken to enough of the magistrates as they leave court in the middle of the morning to know that merely increasing their number won't address the intake. And that there has to be that entire suite of resources throughout the criminal justice system in order to effectively deal with this massive increase in criminal cases. The magistracy undertook a similar review for me of cases on remand, and the conclusion was very similar to that from the report I got from the judge of the criminal division, Justice Richards, in identifying the three main factors in delay in those proceedings and in the number of persons on remand in that court. Can I just say that we remand people according to the bail law? Anybody who is remanded has a right to appeal against a remand. I think looked at fairly, if there was good reason to readmit them to bail, they would be on bail. So we have to consider this. There is a significant cohort of persons who are on remand because they cannot be admitted to bail, for whom this resource issue is a real concern. We shouldn't think of it as a concern for us. It is a real concern for the defendants on remand, because there are different opportunities. I hate to say this, but it's true. But there are different opportunities for serving prisoners than for persons on remand. Yes, education, training, all matter of things. I will just say this. I now start to sound like the DPP. In summary, I just want to give you a figure for the traffic court, because I know this is of a great public concern. I don't have figures for the whole year because of the transition from GEMS to Curia, but the Chief Magistrate was able to provide me with these figures, which I think are really critical. Quick analysis, she says, of the 4-month period between September and December. DUI, driving while intoxicated, 79. Driving without insurance, 98. Careless and dangerous driving, 86. That's for the last third of the year. Now, she makes a bit of a comment on policy, which we don't like to address because of the distinction between the three branches of government. But she does raise for consideration the fact that perhaps the penalties are too low. For driving with insurance, the maximum penalty, alternative imprisonment, is 3 months. The people who are driving without insurance are men of straw. When they have accidents, they have nothing to give the persons that they have injured. So in order to perhaps quicken the uptake of the mandatory insurance scheme, we should be looking at penalties. At least that is what she's suggesting. Although in my own view, the increase in penalties has never changed anything. It is a sureness of being caught, yes? But I think the police are making sure that arrests are made, and so maybe working together, we can address this. Because as she says, most of these people that she sees are repeat offenders, and she says there's a dangerously high number of people driving on the road without being qualified and without insurance. And maybe, Mr. Attorney, I don't know how the English do it, but they have something called the Bureau of something. Motor Insurance Bureau, thank you, which compensates people who have been injured by uninsured drivers or drivers that you can't trace. I don't know, again, we're erring or veering into the area of policy, but something like this could assist the number of victims of road accidents. Just yesterday, I received a snapshot of somebody who'd been knocked off his bicycle, and the driver drove off. Had he been injured, and were he unable to take care of himself, he'd have had no recourse. Last thing, am I last thing yet? Let me see the glazed eyes in front of me. The last thing I want to mention, because I mentioned it in my first opening, and it has haunted me ever since. Even the governor raised it with me. And this is the bringing back the justices of the peace into the court service. I announced it was my intention in 2023. Were you here yet? Maybe it was, yes, you were, yes. No, it was my intention to bring the justices back into the court. It is right that persons in the community take part in the criminal justice system. There's a reason why justice by JP in England, the lay magistrates bench, has lasted 300 years. So what we have done, as I just said, the foundational principle behind the use of lay magistrates, untrained magistrates, is having justice dispensed by people from your own community. Now, that phrase in Cayman might be of particular significance. Yes, having justice dispensed by people from your own community. So on the 5th of September last year, after over 12 months of training and observation and with coordination with the traffic department of the RCIPS, we introduced a court dealing with traffic tickets only. These sittings are for ticket mentions, pleas, and payment directions, and are held every other Friday. And I recognize today Mr. Derek Tibbetts and Ms. Kanisha Boldo, Justices of the Peace, who are part of the current team. And there's also Mr. Andrew McLaughlin. I don't think he's here today. But those three comprise the current roster of Justices of the Peace sitting in the criminal jurisdiction of the summary court dealing with traffic. The JPs are assisted by a legal advisor, and I have to thank Ms. Janisha Simpson, who is our Senior Deputy Clerk of Court, our Registrar of the Court of Appeal, who is also a very busy person, for taking on the role of advising the JPs. She's a qualified attorney with years of experience as a Crown Counsel in what I think was called then the legal department, not the DPP's office. Some days the JPs deal with up to 80 tickets, and according to the Chief Magistrate, this has contributed to improving efficiency within the system. Now, there's much more to be said, but you don't have to take a sharp intake of breath, because I'm not going to say it. I think going forward, we must find a way to permit the Chief Justice to deliver the full report on matters in judicature. So I've left out legal aid. I will say this because I'm sorry the Premier has left, because the numbers from legal aid speak to a burgeoning resource crisis as well. There were 671 new criminal applications, 562 approved, 294 civil and family applications, 140 approved. Of approved criminal applications, 199 were extended, and this has financial implications for the government. I won't tell you, I would love to tell you about the law library and online case reporting. I'm grateful to Mr. McKee for mentioning the work that our law librarian has done in bringing the Cayman Islands law reports back online with the assistance of our IT team. I think we have one of the most user-friendly and useful websites in the Caribbean jurisdiction. I can say this, not even Westlaw has a deep search functionality of our CILR online search engine. Mr. McKee, you agree with me? So really deep functionality. And I understand that Victor, having been pressed by members of the private bar, is trying to make the functionality of the unreported judgments not its equal, but better. I thank you very much, ladies and gentlemen, members of the bar, colleagues, special guests, for your patience. And we're going to take the adjournment now, and I invite all of you to please join us outside for refreshments. You've earned it.
All right. Sound report now standing at 2 p.m.